welcome you. We know we had a lot of interest in the presentation today. In terms of our registered participants, we have about 150 people who were registered, representing 38 out of the 58 counties. We have court administrators, we have judges, we have probation staff, county behavioral health staff and other mental health professionals, people from district attorneys' offices, and public defender offices. So we have a diverse group representing most of the state, and we want to thank you for your attention today. So I'm going to present my colleague Arley Lindberg, who's one of our presenters today. She works at the Judicial Council in Criminal Justice Services as a senior analyst. She's worked for the JCC for about a decade, and she's also been asked to present in part because she's a licensed clinical social worker, and so she has a mental health background that can be helpful in thinking about the way to implement AB 1810.
And Amy Kimpel here is an attorney in our Criminal Justice Services office. Prior to joining the Judicial Council, she was a deputy public defender in Santa Clara County, and prior to that, a federal public defender in San Diego.
And we also just want to say before we move on that we were initially envisioning this webinar to be a moderated panel with courts and other justice partners talking about what's being implemented in their courts and counties. And we found when we polled people that people are still in the very early stages of implementation. And so we are instead going to sort of share what we have learned in our conversations with court partners. So we wanted to explain what the learning goals are today before we get into the meat of the presentation. AB 1810 is obviously a very complicated topic, and we could spend much more than the lunch hour discussing it. So our goals today are to have 3 takeaways for the people participating in the webinar. 1, that you'll have a basic understanding of the new mental health diversion law. 2, that you'll understand the impact of recent amendments and case law. And 3rd, and this is probably what half of the webinar will discuss, is a framework and models for implementing mental diversion in your court or county. There are some topics that we will not cover in great detail. One of those is the procedural challenges of diversion for people with competency issues, and the other is termination procedures for people that are not succeeding in diversion. Those topics may be covered in a later behavioral health education series webinar. This is the first of a series we plan on putting on this year, consisting of probably at least 8 webinars on different behavioral health topics.
The impetus for AB 1810 was partly the increasing number of defendants who are being sent to the Department of State hospitals as incompetent to stand trial. And to give a sense of this trend, from fiscal year 10-11 to fiscal year 14-15, court filings for incompetent to stand trial procedures increased 76%. And at the end of last year, according to Department of State hospital data, there were approximately 840 individuals who were awaiting placement in the state hospital for competence restoration. Department of State hospitals has shared that many of the folks that are coming in as incompetent were not engaged in mental health treatment locally around the time of their arrest. So the intent here is really to connect people to mental health treatment locally in hopes that this will decrease the number of people coming in as incompetent to the hospitals. And more broadly speaking, I'm sure this isn't news to anyone, there is a disproportionate representation of people with mental health disorders in the criminal justice system. So according to National Institute of Mental Health, about 4% of the general population has a serious mental health disorder. And although these aren't perfect comparisons, you can compare that to about 20% of inmates in California jails are receiving psychiatric medications, and about 30% in our state's prison system are receiving mental health services.
And so we understand, because we've talked to many of you and we also reviewed the responses that people provided in the pre-webinar survey, that there are a lot of challenges and concerns about implementing AB 1810. But we want to take at least a moment to sort of acknowledge what a tremendous opportunity AB 1810 could be if successfully implemented in terms of addressing these dual crises, both the issue of the bed space at the Department of State Hospital and the rising number of people who have deteriorated to the point that they're incompetent to stand trial, and then this disproportionate representation and criminalization of folks who have mental health challenges. So we understand that there are challenges, but we hope that you also view this as a potential tool to solving some really significant problems in the communities that we're seeing here in California.
So the statute outlines the purpose of AB 1810 diversion in Penal Code 1001.35, and it reads specifically that the purpose is to increase diversion of individuals with mental disorders while protecting public safety, to allow local discretion and flexibility in developing and implementing these programs, and then to provide diversion that meets the unique mental health treatment and support needs of these individuals.
I just want to point out that the second of these, the allowing local discretion and flexibility, we've heard often from people trying to implement this new scheme that they're a little bit frustrated sometimes at the lack of guidance, and I think you need to view that as actually coming from this purpose. There are parts of the law that are vague and aren't specific, and I think that is designed to empower localities to really figure out a program that meets the needs of their particular population and community and is also a good match for the resources that are available. And it's also mindful of the fact that there's not a one-size-all to dealing with folks who have mental health needs. What services and what treatment and what level of supervision people need is going to vary greatly, and so ask you to look at when you see something where it's vague and there's an opportunity for flexibility to really view that as a good thing because it empowers your local court and your local county to really figure out a way that you can implement this for your own needs. So structurally, we want to talk about exactly what AB 1810 did to the codes. So basically, AB 1810 created Penal Codes 1001.35 and 1001.36. Arley just reviewed with you the first of those two code sections, and we'll review in a minute the second. Basically, that's where we lay out the procedure and the purpose of mental health diversion. And so those are two new statutes. The second thing that AB 1810 did was it amends Penal Codes 1370 and 1370.01, which outline the procedures for dealing with people who've been deemed incompetent to stand trial in both felony and misdemeanor cases, and basically creates a procedural mechanism to potentially funnel people who've been deemed incompetent into diversion in Penal Code 1001.36. And then the final thing that AB 1810 did was it added Welfare and Institutions Code 4361, which outlines the funding that will be available and how it will be dispersed to support not all, but some of the diversion established in AB 1810.
So, Amy, we've gotten a number of questions about eligibility for mental health diversion. Can you go over what's outlined in statute and start with what mental health disorders qualify?
So basically, the eligibility criteria are outlined in Penal Code 1001.36, and the first of those is that you need to have a recent diagnosis of a mental disorder, and that needs to be a diagnosis in the most recent edition of the DSM, which is the 5. There are a couple of disorders that are excluded. Personality disorder, pedophilia would not qualify, and there are some that are specifically mentioned: schizophrenia, schizoaffective disorder, and bipolar, and those are mentioned because the Department of State Hospitals found that those diagnoses represented the bulk of people who were being referred to the state hospital. But that list is not exhaustive. You need a mental disorder that's not one of the very few that are specifically excluded, and if you've ever seen the DSM-5, it's over 900 pages long. So there are a lot of different mental disorders that could potentially meet the eligibility requirement that you have a mental disorder diagnosis.
So could something more common, such as generalized anxiety disorder, be a qualifying diagnosis?
It could. Again, you're going to have to be able to connect that diagnosis to the charged offense, and we'll talk about that in the next eligibility criterion, but something that arguably less significant than schizophrenia would qualify under the statutory scheme. And so, Arley, as a mental health professional yourself, who can provide a diagnosis? Because we know we've gotten some questions from courts about that.
Yeah, so I know that criminal courts are maybe used to working with psychiatrists and psychologists because these are the professionals who can give various forensic reports. However, it is important to note that there are other licensed mental health clinicians who can diagnose mental health disorders, such as licensed clinical social workers, licensed marriage and family therapists, and licensed professional clinical counselors. And these may be the professionals that are going to be working with the defendants who are diverted in the community.
And the statute doesn't specify, as the incompetency statute does, that it needs to be a licensed psychologist or psychiatrist. It just says qualified mental health professional, and so that's why we're talking about exactly who's qualified to give a diagnosis.
Right.
So the second eligibility criterion is that that disorder played a significant role in the charged offense. The wording in this will change a little bit come January 1st of next year because of some amendments that we'll talk about in more detail in a couple of slides, but the language will change to was a significant factor rather than played a significant role. I don't know how critical that distinction is, but basically you have to connect the disorder to the offense. And this criterion actually doesn't require evidence from a mental health professional. It can be gleaned just from the arrest report, and I'm sure those of us who've worked in the courts can remember arrest reports where you wouldn't necessarily need a mental health professional to connect a diagnosis provided by a mental health professional to the role in a specific offense. The third criterion is that the symptoms motivating the criminal behavior from the disorder would respond to treatment. And again, that criterion you would actually need some evidence from a qualified mental health professional. The fourth and fifth are less things that the defendant needs to establish and more just things the defendant needs to do, waiving speedy trial rights, consenting to diversion. There is an exception in the statute. If someone has been funneled into diversion because they've been deemed incompetent, they may not be able to validly waive speedy trial, and so there's some acknowledgement of that in the statute. The fifth is that they agree to comply with treatment because the court will have to approve a treatment plan. And then the last is that the defendant won't present an unreasonable risk of danger if treated in the community. And there's a cross-reference for people who are interested in the specifics, nitty-gritty of the legal code, to Penal Code 1170.18, which is part of Prop 47, and so it's a similar analysis, well, the same analysis as in the Prop 47 context. So again, it's important to recognize that those eligibility requirements set minimum standards. If the defendant doesn't meet those minimum standards, then the judge lacks discretion to grant diversion, but just because the defendant has met those minimum eligibility criteria doesn't mean that there's an entitlement or a right to diversion for the defendant. It's very clear from the statutory framework that the judge may, in their discretion, grant diversion, and as part of the grant of diversion, the judge would need to approve a treatment plan or a treatment program that meets the specific needs of the defendant.
So Senate Bill 215 was signed by the governor in September. Amy, can you go over how SB 215 amends the mental health diversion statute?
I can, Arley. So first, we'd note that what was passed in the end of June, AB 1810, is what is currently effective right now. The SB 215 amendments don't become effective until January 1st. The first thing that they do that changes the framework of mental health diversion is that they create a list of ineligible offenses, and those are what we know as the super strikes, things like murder, manslaughter, rape, some offenses having to do with weapons of mass destruction, 290 registrable offenses except for indecent exposure. And you can look at the code. It will lay them out if you look at SB 215 online. Right now, if someone applies for mental health diversion, there is no statutory ineligibility based on the charge offense, but again, that will change come January 1st. The second thing is that it makes it a little bit more clear what the procedural requirements are and makes it a little bit more clear that the defense has the burden not just to prove the first criterion, the mental health diagnosis, but also the other criterion, because it allows the judge to require the defendant to make a prima facie showing of eligibility and also a showing that both the defendant and the offense are suitable for diversion. And if the defendant cannot do that, then the judge can deny diversion very early on without engaging in a lengthy process. And this graphic just shows sort of increasing the burden to the defendant. The last thing that has changed, besides just some renumbering and that little word-smithing change that I mentioned earlier, is that if there's a request for restitution, the judge is required to set a hearing to determine whether restitution should be ordered. So it provides a mechanism in which the judge can order restitution even in a case where which has been diverted. And again, diversion is a pre-plea program where there's not a plea of guilty and there's not a conviction. So typically restitution is when there's already been a conviction, and so the statutory scheme has been amended to make it clear that the judge is empowered to order restitution in certain circumstances.
And have there been any other developments since AB 1810 passed that impact diversion?
Yes, there's actually been one appellate case out of the 4th Appellate District, and that is People versus Froz. Mr. Froz went to trial. I cannot remember what the charge is. In his trial, he had a mental health professional present evidence that he, I believe, had a diagnosis of schizophrenia. The jury found him guilty at trial, and he was sentenced to prison. And then AB 1810 was passed when his case was pending appeal. And his attorney on appeal asked that the case be reversed so that the trial judge could consider whether Mr. Froz was eligible and suitable for diversion. And the appellate court did that. So it conditionally reversed to allow consideration of diversion, which potentially expands the pool of people who, at least under this case, would be able to access mental health diversion. So now we're going to talk a little bit about diversion for defendants that have been found incompetent to stand trial, people that are funneled into diversion after being determined to be incompetent under 1370 or 1370.01. And sort of have this Venn diagram up here because there's not two separate programs. The same eligibility criteria still apply for people who've been deemed incompetent, and this is really just going to be a subset of your mental health diversion population through a different procedural mechanism. And again, not all defendants in mental health diversion need to be incompetent to stand trial, and not all defendants who've been found incompetent to trial would be eligible and suitable for mental health diversion. And so when we talk about the next couple of slides, we're talking about the overlap between those two populations.
So can you actually walk through how AB 1810 amends the procedures once someone's been found incompetent to stand trial?
Sure. So the beginning of the process would be the same. You know, typically defense attorney declares a doubt under Penal Code 1368. Then the court appoints an expert. The expert looks at the competency of the defendant to stand trial. And if the defendant is found incompetent for a felony, normally what would have happened is that they would be sent to the Department of State hospitals for restoration. Now, if the court's presented with evidence that they may be a suitable candidate for diversion, the court can, instead of sending the defendant to the Department of State hospital, send them to mental health diversion and have them be treated in the community. The diversionary period is a maximum of 2 years. If the maximum period of commitment for restoration is shorter than that, then it would also be shorter than that and would typically be much shorter than that for misdemeanors. And it's important to note that the treatment the defendant would be receiving would not be just for the purpose of restoring them and then reinstating the criminal proceedings. This would be comprehensive mental health treatment that may restore someone to competency, but the goal of the diversion is to treat someone in the community for the diversionary period, and if they complete that diversion successfully, the case could be dismissed. And part of the reason that it's not limited to restoration is there may be some set of people who are incompetent to stand trial who are unrestorable, and that population would be able to participate in diversion as well. And this is just a visual. So instead of going to the state hospital, people being referred to treatment in the community.
So in terms of the funding available, Department of State Hospitals has $100 million to contract with counties to support the implementation of diversion programs And the eligibility criteria here for diversion with these funds is more narrow than what was outlined earlier under Penal Code 1001.36.
And so it's more narrow both than the mental health diversion and than the IST diversion because it is only supporting a narrower subset of even the IST population because of the requirement that it's felony population, and Arley will explain a little bit more.
So the individuals diverted with these funds must be charged with a felony offense, and they must be deemed incompetent to stand trial or have the likelihood to be deemed incompetent. And they must have a diagnosis of schizophrenia, schizoaffective disorder, or bipolar disorder, one of those three. Again, there must be a significant relationship between the individual's mental health disorder and the charged offense, or the conditions of homelessness and the charged offense. And of course, the individual must be able to be treated safely in the community. So the first round of funding is for allocating $91 million, and that's over a 3-year period. And this is for the 15 counties with the highest number of incompetent to stand trial referrals to the state hospitals. And counties must contribute either a 20 or 10% match depending on the county size. And this funding is on a non-competitive basis, so there is already a set maximum amount available to each county, and that's based on their number of referrals to the state hospital. And letters of intent to show that you do want to create these programs needed to be submitted to Department of State Hospitals yesterday by a designated lead agency. And then round 2 funding is available for all remaining counties, and a notification for this funding is expected to be released later this month. And round 2 will allocate $8.5 million, plus I believe any leftover money from the $91 million that perhaps was not allocated to the targeted 15 counties. In addition to funding mental health treatment services, the funding can also go to post-booking jail assessments and can fund up to 15 days of in-custody treatment. And the funds can also go to other services that support someone's well-being in the community, such as supportive housing and substance abuse treatment.
Okay, so in one of those first slides, we talked about the learning goals, and we have finished the part where we're talking about the basics of the statutory scheme and the amendments and case law updates. We are now transitioning to talking about implementation. And so we start with this slide because I think that in our conversations with courts and county partners, it can be overwhelming to think about implementing mental health diversion, especially in light of how many people potentially have a mental health diagnosis who are justice involved. We just talked about how they're disproportionately represented within our justice involved population. And so we're talking about a lot of people that your program could potentially reach. And so the first thing that we've learned from our conversations with court partners is to start small. It is unrealistic to think that if today's Thursday, by Friday, you're going to be able to roll out a program that meets the needs of the 40% of people coming through your courts who have a mental health diagnosis. So think about how you want to start, what targeted population, what capacity, and then roll out something slowly to build upon the early successes and grow your program as you develop more capacity. So different people have thought about this different ways. So some counties and some courts are starting with lower level offenses and then building up as they build up capacity. Some are starting with existing framework through their collaborative courts that already exist. Some are thinking about particular populations or particular levels of care in terms of what treatment needs people have. So there are lots of ways to think about targeting a program and starting small and then building upon those successes.
So in terms of starting small and possibly initially limiting the scope, it's important to have stakeholder collaboration in order to make these decisions. So courts have shared that some of their stakeholder meetings have included the court, obviously, defense, district attorneys, county behavioral health to get a sense of what treatment is available in their system, as well as other treatment providers, probation and or whatever agency oversees pretrial services or supervision, if that's available in your county, and the sheriff's department. And these are pretty much the players that are often present in a mental health court. So if your county already has a mental health court, there's likely some relationships that can be built upon.
And Arley's list isn't exhaustive. We've also heard of some counties involving, or could envision someone involving community-based organizations, peer mentors, graduates of existing mental health courts, or county council, particularly if you're going to be talking about data sharing agreements. So the next slide, one of the things that we have learned is that different counties have really different things happening in their jails with respect to serving people who have mental health challenges. And so I think as you're beginning those stakeholder conversations and beginning the implementation of AB 1810, it's useful to know what's happening in your jail and also to potentially build capacity so what's happening in the jail could further support your program. We know, for example, that in some counties there's mental health screening of every single person coming through the jail. We know that Calaveras County has recently implemented that, and that may be helpful to you in developing AB 1810 because you'll know what the total treatment population could be and have a data baseline. We also know that that information, particularly if it's shared with county behavioral health because county behavioral health is working in the jail, could be a useful mechanism to getting information to the public defender so that they can make initial assessments about who might be able to qualify. For example, in San Diego, the public defender's office has a data sharing agreement with county behavioral health so that they can get treatment records quickly and assess people for eligibility for different sort of mental health treatment courts. And you may be able to build upon an existing system like that. Also, if you have county behavioral health or other treatment referrals working within the jail, you may be able to hook up defendants to treatment even before they show up out of custody to an arraignment and get the process started much earlier. And we know that there are many counties that have referrals to services happening in their jails, whether or not it's county behavioral health who is making those referrals. And the final thing that we know that some folks are doing in their jail is we know that San Diego, for example, enrolls people who come through the jail in Medi-Cal if they're eligible and not already enrolled, and that may help facilitate participation in AB 1810 because you won't have to wait for that eligibility determination and people will be able to more readily access treatment. Okay, so the next thing, so after people have gone through the jail, they get to court. And the next thing that we've heard a variety of different approaches to, and I think it's useful, we're not saying one way is better than another, but you need to figure out how your program is going to operate and how your court's going to handle diversionary cases by asking two important questions. First, who acts as the gatekeeper for diversion? It's obviously going to be a judge, but there are different approaches that we've heard courts making. One is that the individual calendar judge who is hearing the case of someone when they apply for mental health diversion can be the person who assesses both eligibility and suitability for mental health diversion. That's one model. Another thing we've heard courts doing is once someone's filed or requested mental health diversion, the cases are funneled to one centralized judge who creates a little bit more consistency in terms of the determinations, granting or not granting mental health diversion. And when there is a centralized judge, we've heard some courts making sure that that centralized judge is someone who has mental health expertise. It could be the mental health court judge, depending on the capacity and what calendar load that person already has. And then also, who monitors diversion? Is it just going to be that individual calendar judge? Is it going to be one centralized judge? Is it going to be the same judge who makes the eligibility and suitability determination? Or once diversion is granted, is it funneled to a different court for supervision, perhaps in a mental health court or in front of a mental health court judge? Also, if you're going to have every judge who's handling a criminal calendar be assessing these cases, then what educational training do you need for judges to be able to be better equipped to make these determinations about behavioral health issues?
So who provides treatment? Again, the statute allows for flexibility here. It says that treatment can be private or public. So you may have some defendants that are already receiving treatment through their private insurance, and they could continue to do so while they're diverted. There will be defendants who have Medi-Cal and are either already receiving services, perhaps through county behavioral health, or are eligible for services and need to be connected. There can be community-based organizations and nonprofit agencies with mental health services for people with varying insurance types. And it's also important to know if the defendant is eligible for benefits through Veterans Affairs, where if they are, then they could receive mental health services through that system. In terms of types of treatment, there are different levels of care, and the availability of these treatments is going to vary across counties. So the statute outlines that treatment can be in an inpatient or an outpatient setting. So at the highest level of care, there are inpatient psychiatric hospital beds, and we know in many communities, or in some communities, there are actually no such beds available. Then there are residential facilities where there is support 24/7, but it's not a locked facility. And much of mental health treatment is provided on an outpatient basis, and there are different levels of outpatient care. So there are partial hospitalization programs where people spend a significant amount of time in the hospital setting during the day, but then they spend the night at home. There are intensive outpatient services like full-service partnerships, which are basically programs that address pretty much all aspects of a person's life that would enable them to live safely in the community. So services in these intensive outpatient programs can include crisis management, therapy services, peer counseling, medication support, substance use treatment, employment services, independent living skills, and then case management is always an important piece because that's pretty much coordinating all these different supports. You can have someone in individual, weekly, and group therapies. Of course, medications can be an important part of treatment.
And typically, so two questions, Arley, that I have as a non-mental health professional. So one, would every defendant qualify for an inpatient psychiatric bed?
So some of these beds have strict criteria for placement, where someone is usually either, a danger to self or others, or they're in need of some very acute psychiatric care. Again, there are many clinicians who are on this webinar too, so I just want to say if there's something I didn't get totally accurate, definitely let us know. But yeah, some of these beds, they're not available to anyone that would just like them. And to note that there are different levels of care that people are going to enter in
based on treatment needs.
Exactly.
And then the one thing that I think is helpful for judges, there was one comment that we got, the medication and medication management needs to be from a doctor or psychiatrist, right?
It's also important to note that many people with mental health disorders have co-occurring substance use disorders, and so there are both residential and outpatient substance use treatments, and it's beneficial when providers can address both conditions simultaneously.
We've gotten some questions from courts about what the reporting requirements are between the treatment provider and the court. And so the statute does say that the treatment provider needs to, for the treatment program to be approved, the treatment provider needs to accept the defendant. They need to be able to participate in that treatment program. And then the treatment provider needs to provide reports to the court. The statute doesn't delineate exactly how often those reports need to be made to the court, nor do they delineate exactly what needs to be included in those reports. So that's something you may want to figure out at stakeholder meetings to figure out what the best way to do that is. So the next thing that you need to figure out as you're implementing AB 1810 is who's going to be supervising the people that are participating in mental health diversion. So in some situations, that will just be the court, the judge who is supervising the people who are on mental health diversion. And that could be a mental health court judge, it could be the same judge who granted diversion, or it could be a different judge. The other entities that might be involved in supervision are pretrial services, if your county uses pretrial services to monitor people who are out of custody, or probation, if probation has the contract for pretrial supervision, which many more counties will have after SB 10 goes into effect, or if probation is already supervising someone because they have an older case where they're on active probation when they pick up a new case that then potentially could qualify for mental health diversion. And the last entity would be case managers working within the treatment team through county behavioral health or whatever treatment provider it is.
So, Amy, we've talked to a number of courts who have a mental health court already operating and how they are or not incorporating that program into AB 1810 implementation. Can you talk a little bit about what we've been hearing?
Sure. So, in the pre-webinar survey, we got some information that the people who participated in the survey, about 10% didn't have an existing mental health treatment court, 27% were using their existing court to implement AB 1810, but 63% were not. So that gives you some sense, at least initially, of how courts are approaching it. But you do want to think about if you want to integrate it into an existing collaborative court or to use some of the infrastructure for that existing collaborative court. So maybe not on the same calendar, but in the same courtroom because you have a judge and relationships with the treatment team already in place. We have definitely heard from some courts that are implementing AB 1810 by simply changing the mental health court population. So they have a capacity for 40 people in that mental health court who in the past were post-plea people doing mental health treatment court, and now they're going to diversify that population, having 20% of those people be pre-plea diversion and 20 of those members being people who are in the mental health treatment court as they previously were. So that's one way that we've heard courts implementing. If you're doing that and you have some people on a post-plea supervision through probation and some people who are pre-plea diversion, you want to have some consistency in terms of who is getting each track. And so you want to think about what the criteria are and what the factors are that you'll consider. And then another thing that we've heard that may be a useful tool is that you can use other collaborative courts rather than a mental health treatment court. So you could have someone that qualifies for mental health diversion and may be a good fit for your veteran treatment court because they are a veteran or have some military involvement, or they may be a good fit for your drug court because they have a co-occurring substance disorder, and so they can be treated through the drug court with additional support for mental health treatment in their mental health diversionary period. So the next thing we want to do, and hopefully we can get this to work, is we have two people who are going to call in. The first is Judge Lawrence Brown, who is a judge in the Sacramento Superior Court who presides over many of the collaborative courts, and he's going to talk to us. He's also a member of the Collaborative Justice Courts Advisory Committee, and he's going to talk to us briefly about what they're doing in Sacramento in terms of implementing AB 1810.
All right, well, good afternoon, and thank you for giving me the chance just to briefly discuss what we're doing in Sacramento. I think like everybody, we're still trying to figure it out. These are sweeping changes, and it kind of happened overnight, and so we are still kind of catching up with it all. And one of the first steps that we took was to establish an AB 1810 work group, and my presiding judge asked me to chair that and to create it. Since I already preside over the mental health treatment courts here in Sacramento, we have two. So the stakeholders would be the usual suspects: public defenders, district attorney, behavioral health. These are folks we already are all working together on mental health court, and we just added in some additional folks. We now have county exec and probation joining the meetings as the funding piece starts to emerge from the state hospitals. And frankly, the key strategy was to try to break it out to make it somewhat manageable, like referenced by our speakers. And so the first thing we did was put on the back burner, as much as we could, the incompetency to stand trial provisions, partly because the thought was much of that will be impacted by the funding and the application that we put together for the funding, with Sacramento being one of the 15 counties who will receive funding. From there, the method of the madness was to focus on misdemeanors first. And my thought in doing that was it'd be a little less contentious than talking about diversion for felonies, that we would get more ready buy-in from the district attorney's office by focusing on misdemeanors. But it's taken many meetings to get to the point where we now have our procedures in place. And like any procedure, now we'll see how they actually work as they get tested. We have we're told about 60 applications now for diversion that have been submitted in the misdemeanor courts. And speaking of misdemeanor courts, what we decided to do was to concentrate the activity on these diversion matters, these applications for diversion, in our 2 misdemeanor, what we call home courts. We're going to do the same thing with the felonies. We have 4 felony home courts where cases originate. So we don't have a vertical assignment, we have a master calendar system. And the thought in doing that is to concentrate sort of the expertise in fewer departments rather than having the cases heard throughout all the floors of our courthouse here. We have 60 judges in Sacramento, at least 40 would be eligible to have these applications made. And so the thought was instead to train up a smaller number of departments, judges, lawyers, to start working through these procedures. So that's about where we are right now. Do you have particular questions I should address?
No, I actually think that was a great summary, and we're a little short on time. So I want to thank you, Judge Brown, for participating.
You're welcome.
And for the work you're doing up in Sacramento. We're going to shift now to Judge Manley, who is going to talk to us about Santa Clara's approach, which is a little bit different than Sacramento in terms of what population they're starting with first. And again, I'd like to highlight that Judge Manley is also a member of the Collaborative Justice Courts Advisory Committee and is also the chair of the Mental Health Subcommittee of that committee.
Good afternoon. At the same time, let me go quickly here. As with my colleague Judge Brown, we have taken a very collaborative approach here. We have a very large behavioral health court with over 2,000 convicted offenders. We have been working on diversion for 2 years with misdemeanors who've been found incompetent to stand trial. And what we did is we decided to look at this as 2 different programs. The IST program being separate from what we call general diversion. And we have ongoing meetings with all our stakeholders, and we have developed protocols. And what we decided to do, because we have such a strong working relationship with the district attorney, the public defender, and the county behavioral health, is to start with felony and to see if we cannot demonstrate that IST diversion can really work. And the way that is working is we are taking individuals who have been found incompetent to stand trial through the traditional adversarial process in what we call our 1368 court or IST court. That is a separate judge from myself. That judge will make the finding of incompetency regardless of whether the defendant is going to be thought of as eligible for diversion or not. Once that determination has been made, then we return to the other court, my court. We obtain an assessment as to whether or not this defendant would benefit from community treatment, and we make a recommendation. The final decision as to whether or not to divert that client is made by the IST court judge, by a separate judge. It is not made by me. That judge then refers the defendant after diverting him or her to our program, and then it is up to us, and we have already presented a treatment plan to the judge to place that defendant in community treatment. And Arley and Amy have gone over the broad range of treatment programs, and we use them all, including locked facilities. We have very, very few beds, but they are available. And our theory is, or what we are trying to demonstrate, is that if we can make this work with felonies, then in terms of who you choose or who you select or who you decide to divert, we will get past stigma that is attached to the fact that you are a misdemeanor or a felon and you're more dangerous if a felon, and all of that, and we will be able to see if, in fact, we can successfully divert felons at the community level. We have already put the program into effect, even though we have no funding yet, and we have already diverted a number of offenders. Now, our basic concentration, obviously, in the beginning is going to be on low-level offenses, but there are many of them who are sent to the state hospital, perhaps surprising to some, but we are now taking the more serious offenses. And again, that is with the concurrence of the DA, the public defender, and of course, a separate judge from the behavioral court judge. And so that's how we are approaching it, and we meet weekly about our general diversion program that we are developing. I just would add one thing, and that is the greatest challenge we have found is the lack of treatment, the lack of specific treatment for a large number of individuals. It is very limited.
Thank you, Judge Manley, for sharing how Santa Clara is approaching this. And I think you can see from those two case studies that Sacramento and Santa Clara are both implementing AB 1810, but starting with different target populations in terms of their first group that they're rolling out the program, and for different reasons, and using or not using the collaborative court structure. So thank you both for presenting. We really appreciate your on-the-ground perspective. The next thing we want to talk about is data collection, and this is pretty much the last slide because we know we're very short on time. Data collection is required if you're one of the counties who is contracting with Department of State hospitals, but even if you're not required to collect data, it is a useful question to ask about whether you should track data and what data to track, even in terms of the number of participants in your mental health diversion program. And part of the reason that it's important to track that is we know that this is a discretionary program where judges have discretion to grant or not grant diversion, and we know that when judges have more discretion, sometimes that can have the unintended consequence of resulting in some demographic disparities in terms of race or gender or income in terms of who is getting the benefit of that discretion. And so it may be useful to be at least mindful about who is getting the opportunity to participate in diversion, and data could be something that mitigates against disparities. We have a little bit of time for questions. Again, we'll follow up via email for questions that we aren't able to answer here.
So, Amy, I have a question here. It says, in 1368 cases involving misdemeanors, is the individual diverted for up to 2 years or only the maximum time they are facing in the misdemeanor offense?
So it's actually going to be the maximum time that they're looking at for the misdemeanor offense, and that is under 1370.01, where it talks in, I believe it's C1, it talks about what the maximum commitment period is, and then in the diversion statute it says that the maximum will be 2 years or the maximum commitment period if it's an IST case.
Great.
And so, Arley, we had a question about if there's a list of the counties that fall under the Round 1 funding.
Yes, there is. I can just name them real quickly. Alameda, Contra Costa, Fresno, Kern, Los Angeles, Riverside, Sacramento, San Bernardino, San Diego, San Joaquin, Santa Barbara, Santa Clara, Solano, Sonoma, and Stanislaus.
And so basically counties that begin with S seems to be the trend. We are going to answer other questions via email. We had many other questions, but we're short on time. We want to point out that there are a few resources that are available depending on who you are. So this webinar will be available in mid-November after we clean it up on the Judicial Council YouTube channel, where there are some other offerings about drug court standards. There has been a memo disseminated that was written by Judge Cousins and some accompanying materials that are available to judges and court personnel on the Judicial Resources Network. That memo will be revised in probably the coming week to take into account some of the changes in the law in terms of SB 215. There's also a mental health listserv that is moderated by Arley, and so
And that's open to judges and court personnel and also all of our justice system partners, so that can be a great place to post questions to other courts or share resources. It's specific to mental health and criminal justice matters. So if you would like to be added, just go ahead and email me there at my email.
And like Arley said, that's a wider opportunity. The next thing we want to mention is that Criminal Justice Services, the Judicial Council, I am an attorney who staffs that office, and we are available to answer operational questions from courts if that question is approved or asked by a presiding judge or a court CEO. So limited numbers of people participating could access the Judicial Council, and if you have a question related to AB 1810, you can just email me because I'm the person who is point on this.
Great, and we just want to end with talking about our next webinar, which will be on December 13th, where we will be talking with Dr. Lauren Roth of UCSF's Department of Psychiatry. She's also the medical director of San Francisco's Jail Behavioral Health Services, and we'll be talking with her about serious mental health disorders, symptoms, and treatments. And we want to thank you all for joining us during your lunch hour, and we hope that you found this information helpful.
Thank you all, and hope to see you next month.